In my September 2025 post, the FTC buries its ban on non-competes but sharpens its aim on violations. I wrote about the FTC's pivot on non-competes. The nationwide ban was dead, but the agency's appetite for enforcement, particularly in healthcare, was very much alive. At that time, the Commission had issued a request for information targeting physician and nurse non-competes, sent warning letters to large healthcare employers, and made clear that case-by-case enforcement under Section 5 of the FTC Act was the new strategy. On January 27, 2026, the FTC held a half-day public workshop it entitled Moving Forward, Protecting Workers from Anti-Competitive Non-Compete Agreements. In reality, the title of that workshop was a statement of the FTC's direction. At the workshop, FTC Chairman Andrew Ferguson restated what he's said before. He opposed the blanket ban proposed under the Biden administration because the FTC lacked the statutory authority to issue it. And then he said everything that matters for you today. Non-competes can be, and often are, anti-competitive, and the agency is going after the ones it thinks are, but not with a rule, with enforcement. Chairman Ferguson articulated the working standard the FTC will use to evaluate whether a non-compete survives scrutiny. It must A, advance a legitimate pro-competitive purpose, and B, be narrowly tailored to advance only that purpose. His practical formulation: ask whether a less restrictive type of restraint would accomplish the goal or goals that the non-compete is purportedly meant to promote. Think about how that applies to your medical group. If you already have a non-solicitation agreement that prevents a departing physician from raiding your referral relationships and your staff, why do you need a non-compete on top of it? If you have a confidentiality agreement that already protects your proprietary clinical systems and data, what exactly is the non-compete adding? If your honest answer is, well, we just want to make sure they don't compete with us, that's the answer the FTC is looking for, and not in a good way. The workshop also formalized something you shouldn't ignore. The FTC explicitly urged employees who believe their non-compete unlawfully restricts their job mobility to file an anonymous complaint for investigation. The Commission has now built a direct, low-friction channel from some disgruntled physician employee or subcontractor straight to an FTC investigator. Moving forward, you should assume that channel is being used. Most physician group non-competes were drafted to be defensible under state law. That's a completely reasonable baseline, but it's no longer sufficient on its own. The FTC's test is separate from your state's test, and it applies regardless of whether a state court would uphold the clause. The practical question to ask yourself is whether you can articulate clearly and specifically the pro-competitive purpose your non-compete serves that a narrower restriction wouldn't. If the honest answer is that the clause was drafted broadly because broad is harder to get around, well, that's exactly the kind of agreement the agency just announced it's looking for. A few things worth doing now. Pull the non-compete provisions in your physician employment agreements, subcontract agreements, and shareholder or partnership agreements. Look at scope, specialty, geography, duration. Ask whether any of those provisions would survive Ferguson's test. Not your state's test, Ferguson's announced test. Then consider whether your non-solicitation and confidentiality provisions are already doing the work the non-compete is supposed to do. If they are, the non-compete may be generating regulatory exposure without providing meaningful additional protection. Finally, document your reasoning. If you have a legitimate business justification, such as protecting a genuine investment in physician training, maintaining patient continuity during a transition period, preserving proprietary clinical methodology, document it. The FTC's case-by-case approach means that articulated, defensible justifications matter in a way they didn't when the agency was swinging a broad hammer at everything. Let me shift gears for a moment. For the individual physician who signed something, a subcontract, an employment agreement, a buy-in document, with language in it that says that you can't practice within a certain radius for a certain period if you leave, its enforceability is in question, but the answer is more complicated. It depends on the state, on the specific facts, and increasingly on how your agreement would look to an FTC investigator measuring it against the chairman's test. The agency has now made explicit that physicians are a priority population for enforcement. If your non-compete is overbroad, broad geographic scope, long duration, no apparent connection to a legitimate interest that a narrower clause couldn't serve, it is precisely the kind of agreement the FTC just announced it's looking for. That doesn't mean that your non-compete is unenforceable or that the FTC is going to arrive like a cavalry unit and nullify it. It means the landscape has shifted in a way that's worth understanding before you decide whether to stay, negotiate, or leave. Here are some timely takeaways for you. Number one, the blanket ban is gone, the attention isn't. The September pivot and the January workshop together send the same message. The FTC is not doing theater, it is building cases. Healthcare, specifically medical practice, was the prime industry discussed at the January workshop. Number two, run Ferguson's test on your own agreements. For every non-compete clause you use or are subject to, does it advance a pro-competitive purpose? Is there a less restrictive alternative that would serve the same goal? If you can't answer both questions comfortably, someone else will eventually answer them for you. Three, treat the anonymous complaint mechanism as a real variable. If you run a group and have a physician who is unhappy enough to complain, the FTC has made that path frictionless. The practical defense is a non-compete that couldn't reasonably be characterized as overbroad or otherwise anti-competitive in the first place. Number four, state law is the floor, not the ceiling. Several states largely or entirely prohibit non-competes as a matter of state law. Some have physician-specific laws. Even where your state permits non-competes, the FTC's federal enforcement authority is a separate layer. You need to understand both and how they interact. And five, if you are evaluating a departure, understand what you actually signed. The specific language matters. The state matters. The nature of your role and the scope of the restriction all matter. Don't assume the clause is enforceable, but don't assume that it isn't. In the event that you'd like to review your group's non-compete provisions or take a hard look at an agreement you're currently subject to, get in touch.